All right, we've been listening to Clinton Frazier deliver his closing arguments to the jury in Tennessee versus Eric Boyd. His client is facing a lifetime in prison. There's not a lot of physical evidence. No, there's no physical evidence tying Boyd to the actual murder and rape of the two victims in this case, Shannon Christian and Christopher Newsom. But there was a compelling witness, whether you believed him or not. George Thomas came in and basically said that his buddy Eric Boyd was involved. Now it's up to this jury to decide what to do. They've been at it for 7 hours and 6 minutes. You see the jury clock in the corner of your screen there. Michael Bixon and Cynthia Counts have been watching all of this with us. And Michael, you just joined us. Welcome. Your thoughts, first I want to get your thoughts. We talked about it earlier, the question that the jury had last hour. You think it means it's bad news?
I think it's terrible for the defense. Because, I mean, the way that they framed the question indicates that they think that he was there, that he was present during the crime. And that's really the only question you actually need to ask, right? Was he there when everything was going down? Because if he was, that should be it.
What if he was only there during the carjacking? He gave them a ride to the carjacking, and this jury doesn't believe there's enough evidence to put him at the house.
It becomes more difficult because they really never pinned down where all of the crimes happened, right? So did they all happen at the house? And we sort of heard that when, the co-defendant takes a stand, Thomas, right? Yeah. And he was talking about, well, he's not sure whether or not something happened in the car. Obviously, we know that something happened to the house. But if something happened in the car, yes, maybe he was only there for that portion of it, but he could still be sort of held liable for that as well. I think as long as they're putting him there, even just in the car, it's not going to look good. Right. So it really is more about where he was during, I guess, where everything was going down.
Because the only other scenario is you have a four-person who is very detail-oriented, and they're going through these 36 counts, and one or maybe one or two people just brought up this question. Well, what about this? And they're kind of getting into the weeds, which is highly doubtful. I think I agree with you that it doesn't look good for Mr. Boyd at this point, but you never know. They've been at it for a long time. Let's talk about the closings that we're watching here. When we watched the opening statements in this trial, they were underwhelming on both sides, really. And all of this whole trial has been kind of this, like, everybody's speaking very softly. Nobody's getting animated. And we're seeing that play out here in the close for the defense as well. Cynthia, I guess it's just sort of the way this trial has gone. But I don't know. If I'm a juror, I want a little passion from the lawyers.
Certainly, and I think you called it the whisper trial. I think that should be the name of this case. At the beginning it was hard to hear,
right.
When they were.
And part of it is these aren't our cameras and microphones. We're working with some local affiliates, and we don't have great audio quality. Still. Nobody's raising their voice.
Or their hands.
It's very just walking around. But I guess, it doesn't matter, the theatrics of it all. The jury is going to see all through that. You can have a boisterous attorney who, if you don't have the facts on your side, you're in trouble, right?
But it looked like the facts were on there. No physical evidence. You have a very suspicious witness with Thompson. He's got every motive to lie, and he looked like a liar on the stand. And he didn't say he was his buddy. He said clearly he didn't really know him that well, is what I recall.
Yes.
So, I would have thought that would be reasonable doubt, but it sounds like, I'm with you, that question causes some concern, unless they're just debating.
So if you throw George Thomas out of the mix, and you're on this jury, could you still come back with a guilty verdict?
There's no way. There's no DNA, there's no fingerprints. We have two witnesses both saying that they actually didn't see him at the house.
Right.
This should be an open and shut case, even, I think with him, because I think there's so much that goes against Thomas's testimony that just destroys it, right? The plea deal that he's getting out of this, and so far down the road, the credibility is just out the window. This should be open and shut, but the biggest problem they have for the defense is that, they're seeing red, and you can't blame them because it's such a horrible set of facts that you feel impassioned about it, and you want to find somebody guilty about it, even if they're not.
Cynthia, we talked earlier about the fact off camera that his criminal history doesn't come into play, and that's for a good reason in most trials. The defendant's criminal history shouldn't come in. But in this case, it would have helped him if the jury would know that he is incarcerated right now. He is paying for his crime of aiding and abetting, basically helping the, after the fact, one of the defendants. But they don't know that. And does that play into the juror's natural reaction to want to do something?
I think so. I mean, jurors are going to want accountability, and he was doing something. It's kind of like, don't hang out with dogs because you'll get their fleas or whatever. I mean, he was clearly part of this group, and the jury is going to want to punish him. He has been punished 12 years, right? But
Yeah.
they don't know that, and I would want them to know.
How, in your experience, Michael, when you say he's part of a group, he is, that's been established, that he's friends with them, they've interacted during this time period. Do jurors have a mentality of like, you know what, I don't care about the details. He's part of that disgusting group that committed, everybody agrees, a horrible crime.
Guilt by association is a very, very strong and persuasive argument, right? And for a prosecutor, it almost, once you throw that out there, I mean, people see it, even when you just have two co-defendants sitting at a table next to each other, no matter what the facts allege that each one did, they see them sitting at that table and you get that instant guilt by association. For him, I think, to sort of go back and that could be a downside to them trying to introduce, if the defense did try to, that he already has sort of served this time, to tie him into them a little bit more, to say that he did help them after the fact. It could also hurt him, right, by tying him into their sort of group a little bit more than he already is. But like you said, I do think that there is a very strong argument to be made out of that he already has done his time. Hasn't come out, so.
Hasn't come out. One of the worst cases of guilt by association in recent memory was our first case on Court TV here. Remember when Courtney Bell was having to sit next to Mr. McNabb? That was the worst. Imagine having to sit next to that guy. Anyway, we're going to take a quick break. Jury has been seated, we're being told, in West Virginia. What does that mean? We're expecting opening statements to begin around 2:30. Apparently they're having a little lunch break now. But they have a jury, and we're going to hear opening statements in the murder trial against Morgan Vandergriff. Stay with us. You're watching Court TV. Welcome back to Court TV Live. I'm Ted Rollins. We are covering a trial in West Virginia this week, and the jury has just been seated. We're expecting opening statements at about 2:30 this afternoon. Morgan Vandergriff is accused of killing 38-year-old John Maynard. He's a father in a hit-and-run incident. Vandergriff was allegedly speeding down a residential road where a school bus ahead of him was starting to make a U-turn. That is when John Maynard apparently jumped off his four-wheeler and began shouting and signaling for Vandergriff to slow down and avoid a collision with the school bus. Well, authorities say Vandergriff then accelerated and turned his Chevy Cavalier towards Maynard, killing him with the impact. Jury selection, as we said, just finished up. They have a jury, 8 women and 5 men. They're on a lunch break. We're going to bring you opening statements. We're expecting them to start at 2:30 this afternoon, Eastern Time. So meanwhile, we're in verdict watch over in Tennessee versus Eric Boyd. You see the clock in your screen there. They've been at it for 7 hours and 18 minutes. What will they decide? Well, we've been listening to the closing arguments from the defense team. Let's continue where we left off.
Let's talk a little bit about what is the state's key evidence that they have against Mr. Boyd. What is this? Well, it's probably the first witness to talk about is Xavier Jenkins. Mr. Jenkins, of course, is just working. Comes there and is minding his own business and sees commotion going on at 2316 Chipman Street. What did Mr. Jenkins also say? Well, initially he reports the SUV. Of course, he sees the SUV pass him later on that evening. He says, General Morton said that he saw 4 black males, but again, when I asked him some questions, he said I saw 4 silhouettes that I assumed to be black males in the vehicle when they passed me. Again, he said he didn't see the features of anybody, but he saw 4 silhouettes in the car. Now, And of course, he testified that later on the next day they saw the car parked over by the train tracks, and you know, they went to go see if there were any kids in it. There weren't. It was empty. They went back to work, and that's what he initially says. And then we have, shortly before the federal trial, federal prosecutors go out to talk to Mr. Jenkins. In October of 2007, they go out to talk to him. That's 9 months after he witnessed these events. And they ask him about, hey, did you see any other cars out there? Why, yes, I did. I saw a white car with a little red pinstripe that was sitting out there. Now, let's again look at what we're talking about. Mr. Jenkins is over in this parking lot, 2316 Chipman Street is over there. He says he's sitting sort of catty corner. It is at nighttime. There is going to be light in this area and light over here, residential. He says that he saw the lights on at the house. He testified that that was about 300 yards, a football field away. And from that distance, at that time, sitting catty corner, not particularly paying a whole lot of attention to whatever's going on at 2316 Chipman Street, because of course he has no reason to think there's anything going on at 2316 Chipman Street. He sees that white Pontiac Sunbird with that little thin red stripe from that distance, and that he remembers that 9 months later. Some pretty incredible perception and recollection. Now, I just want to be clear about this. I'm not saying for an instant that Mr. Jenkins is lying or that he is intentionally trying to say something that he believes is false. This case, as we know, was a huge media event. Pictures of the individuals who were involved in this case were broadcast and rebroadcast. We know vehicles were broadcast and rebroadcast. This case saturated the airwaves for years. Mr. Jenkins says that he did not watch any more media coverage at all after the first reports that showed the 4Runner, which he recognized and said, hey, that's the car that I saw. He says he didn't see any pictures of the Pontiac or pictures of Mr. Boyd that were broadcast on the local news. He says he didn't see any of those. Again, that's just something we're gonna, I guess y'all have to decide in considering how much weight to give his evidence. Because certainly it would make sense if they're broadcasting and rebroadcasting and that Sunbird is on TV, why Mr. Jenkins may be able, 9 months later, to pick out a car that he saw from a football field away.
All right, Clinton Frazier telling the jury that he's not saying that Xavier Jenkins was lying, but he kind of was, wasn't he?
Maybe misinformed?
Yes, the implication is that right away after this took place, he calls the police and says, I recognize that 4Runner. 9 months later, he comes up with the Sunbird with the little red stripe, and according to his testimony, he's 100 yards away, a football field away, and that's actually pretty compelling because the idea that he would remember this little car with the red stripe that far away on a random night is a little hard to believe, but the implication clearly is that he was either fed this by, I don't know, prosecutors would be the worst case scenario, but the media, there's this implication that he was lying. Do juries like this when you attack a witness? Because he, on the stand, seemed very credible to me, Xavier when he was up there, Xavier Jenkins. Your thoughts?
Well, it depends on how you attack, right? I mean, I think they expect you to cross him and question him. And I don't think he's being overly aggressive, and you heard the way that he presented it as, I'm not saying that he's lying, but maybe he's just misinformed about how he remembers or why he remembers certain things. And that's certainly possible.
And he makes a good point, doesn't he?
Oh, eyewitness testimony is inherently, hard to believe. And I think it goes to cars just like it does people. I mean, the eye, what you see, what you think you see, and if you did get any of these images fed to you in any way, shape, or form, you may not realize that he was impacted, but people do all the time.
George Thomas was clearly the most pivotal witness for the state of Tennessee, but Xavier Jenkins was second. I mean, this guy was the only other person to really bring that Sunbird into play. And by saying that he was sitting there overnight and he witnessed this car at the house behind the 4Runner is damning for Eric Boyd. And listening to this defense close, pretty good idea to attack him, I guess, because that is the linchpin, isn't it? If you assume that the jury doesn't believe.
If they don't believe Thomas.
Yeah.
If they don't believe Thomas, then yes, I would say. But even the car itself is such a weak link. I mean, he's not saying he saw Boyd in it. He's not saying I ID'd him. And that's
nobody
him.
saw Eric Boyd driving this car ever.
Yeah, well, that's my point. Maybe he wasn't in it. Maybe because they were his friends, they drove the car. Maybe he left it there. Maybe they had access to the keys. But
Maybe you should do the closing.
yeah, well, maybe, yeah. I mean, a little passion certainly couldn't hurt. But, at the same time, by no means whatsoever, if you were to look at this case objectively, should that car be the linchpin? Now, it might be, but I don't think for the right reasons.
Right, and that's a good point. And throughout this whole thing, no one has said they saw Eric Boyd driving that Pontiac Sunbird yet. There's been enough that has tied Eric Boyd to this group and this car, potentially to this house, that jurors are making this connection. And I know, Cynthia, you want to jump in and say something, but we got to take a quick break. So we're going to come back and you're going to jump in with your thought. When we do come back, we're still on Verdict Watch, 7 hours and 26 minutes, Tennessee versus Eric Boyd. And we're continuing our coverage in West Virginia, where a jury has been sat. They're on a lunch break now. Around 2:30 Eastern time, they will be back in the courtroom, and we're expecting opening statements in that case. Lots ahead here on Court TV Live. Don't go away.
I've sentenced you to life imprisonment without any possibility of parole, and God have mercy on your soul.
We're recapping everything in both the Amato and Boyd trials. Plus, we'll break down day one in our next big case, the school bus stop murder trial. Prosecutors say Morgan Vandergriff was illegally passing a stopped school bus when he intentionally steered his car to strike and kill John Maynard.
Closing arguments with Vinnie Politan tonight, starting at 6/5 Central on the all-new Court TV.
Welcome back to Court TV Live. I'm Ted Rollins. A jury has been seated in West Virginia. We're covering the hit-and-run murder trial of Morgan Vandergriff. He is accused of killing 38-year-old John Maynard in a hit-and-run in May of 2018. Maynard allegedly spotted Vandergriff speeding down Ranch Lake Boulevard in Scott Depot, West Virginia, towards a turning school bus filled with children. So he waves his arms, yells at Vandergriff to slow down, and then, according to witnesses, Vandergriff plowed into Maynard's body. Maynard died from the impact. While we wait for that trial to begin, we are also watching Boyd and Tennessee. The jury's been out for 7.5 hours. We're in verdict watch there. So, since we didn't get to hear all of the defense or all of the closing arguments from the defense yesterday, we've been watching them piece by piece. Let's pick up where we left off.
I think what I can also would like to point out that testimony of Danielle Lightfoot, one of the last people that we heard from in this case, that she testified that Daphne Sutton also drove a little white Pontiac car and had given her a ride over to a hairdresser. So that might be another explanation for that white car. Then the state's other key witness, that being George Thomas. State said that they were going to bring you someone from the inside to answer the questions about what happened at 2316 Chipman Street. Y'all heard him. What do we know about Mr. Thomas? Well, we know that he and LaTalvis Cobbins are best friends. We know that he and LaTalvis were present during the abductions, rapes, and murders, and that after the crimes were committed, they fled to Kentucky. We know that in Kentucky, they're caught with Shannon's property. When they talk to the police, both implicate Eric Boyd. But neither LaMarcus nor Vanessa Coleman implicate him. Details about E, those come through again, the investigators, the interviewers. And George runs with the ball. And he's loyal to LaTalvis. He doesn't know Eric Boyd. He doesn't know him. He's loyal, so loyal to him that he doesn't even directly implicate LaTalvis in the crimes that took place at 2316 Chipman Street. Even when he testified the other day, he didn't implicate his best friend. Well, let's look at some of the statements, various statements that Mr. Thomas has made. The type of gun changes. When he talked to investigators back in 2007, he said, it's a revolver. And here, it's an automatic. His story about who took Chris Newsom changed. His original statement was LaMarcus Davis and Eric Boyd, and then it changed to, well, it's just Eric Boyd, and then now it's, well, it was me and Eric Boyd. He told us that LaMarcus Davidson and Eric Boyd go into the front room with Shannon Christian. And y'all heard on cross. That's different, and that conflicts directly with what he told Investigator Childress just a year ago about what happened. He also now says that Eric Boyd was alone with Shannon Christian while he, LaMarcus Davidson, Vanessa Coleman, LaTalvis Cobbins went on a trip. Driving around, they went over to Vincent's house. And while that's going on, and they're going to Vincent's house, back over at 2316 Chipman Street, Eric Boyd is sitting with Shannon Christian, I guess, committing the crimes? I don't know. He's sitting there with her. And again, that directly conflicts what he told Investigator Childress when they made this agreement for him to come in here and testify a year ago. Now, the state, if you'll notice, they didn't call any witnesses to rebut that part of my cross-examination of Mr. Thomas. That statements made to Investigator Childress didn't match with what his testimony in here the other day was. They didn't call Investigator Childress to rebut that. They didn't call anybody. But they did whenever we talked about the statement back down in Kentucky. They brought the sheriff in, former sheriff in here to rehab his statements from Kentucky. According to Mr. Thomas, he didn't see anything. He didn't hear anything. And y'all heard him. He didn't think he should have been charged. He didn't think he should have been charged for this, for his involvement.
All right, Michael Bixon and Cynthia Counts are with me here. I mean, this guy's whispering the whole closing arguments. We were just talking about it. Boy, have you seen anything like this? Where this is supposed to be the most passionate part of your case, where you're saving your client. Literally, there was a woman in the gallery sleeping.
His client's life is on the line, and I'm falling asleep watching, which is a really bad standard, right? I'm falling asleep watching this, and we're talking one of the most horrific set of facts, and probably one of the best cases I've seen for the defense, and he's just going this slow, easy, measured tone, just not engaging the jury at all, not engaging really anyone, which is a shame because he has such a good defense. And the way that he's delivering it is killing it.
Cynthia, now we're not in the courtroom. He might be making, eye contact, and the acoustics in the courtroom might be to where it is library-esque, and you're, he's connecting. We don't know, but it does seem though that there could be a ramping up of the passion level.
There certainly could be. I mean, his tone is just so low, and he's not even standing near the defendant. He's not seeming to connect with the defendant. He even said at one point it might be, remember, not that it was. Right. He's repeating a lot of what you would hear from the prosecution, and then just saying, well, make up your own mind. I think that's unfortunate because they're missing a lot.
All right, they've been at it 7 hours and 38 minutes, this jury deliberating the fate of Eric Boyd. We have it in the next hour, another trial coming up here on Court TV. This is West Virginia versus Morgan Vandergriff. And the gist of this trial, as we've been telling everybody, is that Morgan Vandergriff apparently is driving too fast in a residential area. There's a school bus making a U-turn, and a neighbor who's sitting outside says, slow down. We see it happen all the time. And I've done it in my neighborhood. Slow down, you crazy kids. And but he ends up swerving and hitting him. The allegation here is that he's facing first-degree murder charges. What do you think the defense is going to be in this case, given that there's eyewitnesses that seem to support the prosecution's theory that it was intentional? What do you think, Michael, is going to be the defense, or should be the defense argument here?
It's not first-degree murder, right? They have to argue.
It's not.
No, and the argument has to be that really it's a lesser included. I mean, there's no, question here that crime was committed. I don't think. Right. I mean,
but what if the idea is that Vandergriff is driving down and he sees this guy yelling at him and then just literally says, "I'm going to kill that guy." Because he's on meth. His intent is to kill this man who's yelling at him.
Well, that's the argument from the state.
Yeah.
But I think from the defense, the argument becomes that he was high on meth, but this is a DUI and a death that resulted sort of as a consequence of the DUI, but this wasn't premeditated, this wasn't deliberate, it wasn't willful, this is reckless conduct. And those two standards are two different crimes and with very different results. So for the defense, I think they need to try to go away from that willful, deliberate, premeditated standard and go more towards reckless. We know that they have that witness that they want to bring on, the expert, and I think it's exactly what he's going to testify to.
Cynthia, you agree?
I do. I mean, I think the question is going to be whether he was capable of coming up with intent. I mean, you can have intent in seconds, so that's not really the issue. But if you're high on meth, and I think he was found
with meth in his system, we don't know the levels of it.
That'll be important, I suppose. I don't really know, but it seems like that could impact the ability to have intent.
What about his story that he was avoiding a beer can or bottle that he says the victim threw at him? And the eyewitness says the victim in this case was carrying a beer, was holding a beer. He was sitting on basically one of those four-wheelers in somebody's driveway. They're just sitting there talking, having a beer when all of this occurred. Should the defense be pushing this narrative? I mean, because this is what your client said immediately after it happened.
It's a tough sell. It's a really tough sell. I mean, even the logistics of it, when you think about it, if I throw something, right, if you go away from whatever I'm throwing at you, you shouldn't be coming at the same source of whatever threw the item, right? I mean, if I throw a beer bottle, you would naturally go away from me, not towards me. It doesn't really make sense.
Even if you had a choice, like you hit the beer bottle, not the man.
Yeah,
you just.
Granted, meth, right?
Right.
But at the same time, no, I would go far, far away from that argument. And I think it comes back down to, look, I would show the picture of how he looked after the arrest. He looked terrible. He looked like he was methed out, right?
Right.
I mean, and you want to sell that as much as possible to the jurors, that he had, the willful, deliberate, no, this had nothing to do with this. This was reckless conduct as a result of him using meth.
Right. Big Lebowski on meth.
Absolutely, yeah.
And apparently he is very cleaned up. It'd be interesting to see how he looks when we get a look at him in the next within the hour. We're going to be inside that courtroom watching this take part. Cynthia, I guess is a stupid question. You're going to clean that guy up, right, before you put him on the stand or at the defense table. How important, though, since we're looking at him, is appearance and the meth in the system. To some jurors, that instantly, people do make that connection, don't they? Oh, meth, guilty.
Maybe, certainly.
If you're a drug user, you're bad. You're a bad person.
Well, you can always take your idea and have him come in with a white Russian and a robe, maybe. But no, you have to clean him up. I mean, you want people to look at him and see him as a person that they can have compassion for, not somebody that they're afraid of.
And you do need the jurors, don't you, to sometimes put themselves in the defendant's chair. Could I be there? What scenario could I be actually sitting there? And that's why I think a lot of jurors know that they don't do meth, so they'll never be there. But from the driving situation, that's it's got a little bit of road rage maybe in there, or speeding, and we've all been driving, and we've all been driving with different mentalities. If on both sides of a road rage incident, that don't get out of hand, of course. But is there something that is, I guess. There's nothing endearing about this this defendant, but is there something where they can make him look as though maybe he's overcharged? How do you make him have some likability? Because look at the guy.
It's tough when the murder happens in front of a school bus filled with kids.
Yeah.
That becomes really, really difficult, right? To get that likability factor, or even just not to hate his guts instantly. And if they bring some of these kids in to testify,
which they're going to, yeah.
Yeah, game over at that point. I mean, they're going to, just the emotion that you're going to get out of a child going up there and testifying about something as terrible as this, especially if they bring in, children of the guy who's, God, just terrible.
Yeah, they're not going to bring his. John Maynard did have a daughter, I believe, a young child, but his child was not on the school bus that he was going out to protect. Mm-hmm. But you're going to have some students who will be testifying, saying that they witnessed basically this adult that they knew being hit by this car. It'll be very compelling. All right, we're going to take a quick break. When we come back, more of our coverage from West Virginia and from Tennessee. We'll have live coverage from West Virginia as we're waiting for opening statements. Plus, we're on Verdict Watch in Tennessee. Stay with us.